Hello guys, welcome to Cognition's IAS coaching. So this is a live of ARC reports. I hope you see on the first slide that is second ARC report number one, that is right to information. So as I said in the previous videos that I am going to start ARC reports, which is very important for USPSC preparation. So I hope everyone is doing good. Everyone is being prepared for the IAS preparation from chapter NCERT chapters and newspapers. So I already said what is ARC reports. I hope you all understood what is ARC report. So if you didn't watch that video, just I've given link in the description. You can check out there. Or again, I will say in this video. Don't worry. So I hope now uh, just so this is a summary notes for the second ARC first report, that is right to information. If you want this notes, summary notes, join the Telegram group. It will be uploaded in the Telegram group. And the main report, which is the main report, the main ARC report also will be uploaded in this group. So just check. I have given a link in the description. You can check. So before going to the report, let's see what is this ARC reports. So the ARC are the Administrative Reforms Commission, as a committee set up by the government to review and set the public administration system, and which gives some recommendations to improve it. Which 1966 the first ARC was headed by Moraji Desai initially after K. Anamanath, and the second ARC, which is in 2005, was headed by Virappa Moili. So these were the reports published by the Administrative Reforms Commission. As I said, the first ARC was set up in 1966, and which is to examine the public administration of the country and make recommendations for reform it. And the second ARC reports, which is 2005, prepared a detailed blueprint to revamp the public administrative system. It submitted somewhat 15 reports to the government covering areas like RTI, ethics in governance, local governance, terrorism, public administration, e-governance, financial management, and so on. So, the second ARC report, which was prepared in 2005, is beneficial for IAS as well as for UPSC mains preparation because it offers a detailed information on public administration system and some changes required. And you know what? This subsequent reports published by second ARC can be read by the aspirants, which helps them for the general studies paper to general studies paper for mains papers. And you may get a doubt how to read this ARC report for UPSC exam. Don't worry. This ARC reports contain a lot of material, and these reports are very useful also. So don't need to ready everything in the report. The Cognizance IAS coaching will be providing the summary notes, the Telegram group. Just check it and refer it. If you want know more about that report, you can read the original report, which will be some of what 60 to 80 pages, right? So today we are going to discuss the first report, that is right to information. And all you may get a doubt, all 15, like there are 15 years reports, is it important to read all 15 reports? No, it is just you can read just for 7 reports, that is report number 1, report 3, report 4, report 8, report 11, report 12, and report 14. That is right to information, crisis management, ethics in governance, combating terrorism, promoting e-governance, citizen-centric administration, financial management. Don't worry, our Cognizance IAS coaching in this channel, all 15 reports will be in live, and I will also try to give you the first ARC reports also for your preparation. Okay, so I hope you understood what is ARC reports. These ARC reports contains a lot of case studies and some quotations which you can use in UPSC Civil Services exam. You can write that gives you more marks. That is why we say ARC reports are more important. That is why just concentrate on what I'm saying, and today let's discuss the first ARC report, that is right to information. Right to information, master key to good governance. So again, I'm saying the important notes and the original report will be uploaded in the Telegram group. Link in the description. You can just check out there. Okay, so let's get started with the report. Okay, so the second Administrative Reform Commission, which has been constituted to prepare, as I said, a detailed blueprint, somewhat for revamping the public administration systems. And you know what? This commission had been given a wide terms of reference covering all aspects of public administration. The commission, in its first report, decided to analyze given recommendations on the freedom of information, which is right to information, which has been enacted recently, and somewhat it's a shift and it's a paradigm shift in administration. So, the Right to Information Act is a path breaking legislation which signals the march from darkness of secrecy to dawn of transparency. It lights up the mindset of public authorities, which is close with suspension and secrecy, openness, and the excess of public power. Executive, legislative, judiciary, which is a improved with privacy confidentially being an exemption case. So the right to information will also be a powerful means for fighting corruption. And this effective implementation for the Right to Information Act will create an environment for vigilance which will help promote functioning of a more participatory democracy. Right? So in this report there will be 8 chapters. So first chapter is introduction, and next chapter, chapter 2, Official Secrets Act and Other Laws, some rules. Chapter 3 is Rules and Procedures. Chapter 4 is Confidently Classification. Chapter 5, Rights and Obligations. Chapter 6, Issues and Implementation. And Chapter 7, Application of the Right to Information Act to Legislature and Judiciary. Chapter 8, Removal of Difficulties, which is conclusion and summary. Right? And one more thing, guys, everything what we learn in this is just a recommendation given by the ARC committee for good governance in India, for the government of India, right? So let's go with the introduction, chapter 1. If liberty and equality as a thought by some are chiefly to be found in democracy, they will be best attained when all persons alike share in the government to be utmost. So this right to information, which has been as a key of strengthening participatory democracy and some ushering in people-centered governance. So this give access to information can empower the poor and weaker sections of a society, which demand and get information about public policies and actions, therefore leading by their welfare. One more thing, without good governance, no amount of developmental schemes can bring improvements in the quality of life of the citizens. Good governance has 4 elements: transparency, accountability, predictability, and participation. Transparency, which refers to the availability of information which is given to the general public and clarity about the functioning of governmental institutions. Right to information opens up government's records for public security, thereby arming citizens with a vital role to inform them about what the government does and how effectively it is making the government more accountable, announcing predictability, which is information which about functioning of government also enables citizens to participate in the governance process effectively. And in the fundamental sense, right to information is a basic necessity for the good governance. In recognition of the need for transparency in public affairs, the Indian Parliament enacted the Right to Information Act, hereinafter referred as RTI Act, in 2005. It's a path-breaking legislation empowering people and promoting transparency. While right to information is implicitly guaranteed by the Constitution, and this Act sets out the practical regime for citizens to secure access to information on all matters of governance in the words of Prime Minister. Efficient and effective institutions are the key to rapid economic and social development. Institutions which can translate promises and policies and actionable programs with at least possible cost and the maximum possible efficiency. Institutions which can deliver on the promises made, they don't convert outlays into outcomes. For institutions to be effective, they must function in a transparent and responsible and accountable manner. And this right to information bill will bring into force another right which will empower the citizen in the regard and ensure that our institutions and functionaries discharge their duties into the desired manner, which will bring into effect a critical right for enforcing other rights and fill a vital gap in citizen framework of rights. This law is very comprehensive and covers almost all matters of governance and has the widest possible reach being applicable and to government at all levels, union, state and local, as well as recipients for government grants access to information under this act is extensive with minimum exemptions. Even these exemptions are subject to strict safeguards. So, as may be expected in a new legislation of this kind, permanently impacting on all agencies of government, there are bound to be implementation issues and there are some problem areas which need to be addressed. Right? So, Commission therefore decided to look at the implementation of this new legislation and make suitable recommendations. Suitable recommendations. So, and largely sustained to fulfill the objectives of the act while the act applies to all branches of government which is executive legislative judicial. Their commission study and recommendations largely pertain to the executive branch at all. However, the commission has also carefully examined some of the key issues which need to be addressed in the legislative and the judicial branches for effective implementation of the act. It is for the complement authorities of the legislatures and judiciary to examine these recommendations and adapt them with modifications to suit their requirements. One of the terms of reference of the Administrative Reforms Commission pertains to the freedom of information, specifically in some following aspects, which is to review the confidential classification of government documents, especially with reference of Official Secrets Act, to encourage transparency and access to non-classified data, disclosure, information of and transparency as a supplement to the right to information of the citizens. The Commission has examined the relevant laws, rules, and manuals which have an impact on freedom of information, which has specifically examined the Official Secrets Act. And this Indian Evidence Act manual of departmental security instructions and those pertaining to office procedures and conduct rules and made recommendation in respect of those. In order to elect views from different stakeholders on freedom of information, the Commission organized a national colloquium at the National Judicial Academy. So, Bhopal in December 2005, the list of participants in the national colloquium organized by the Commission on the subject is an actual one. So, the recommendations of the colloquium, the questionnaire circulated to various stakeholders, and the case studies conducted are relied by the Commission in 9x3. Why? And the comparative study of transparency laws of the various states and other countries and as 1 5 and 6. The report is in two parts. Part 1, which focuses on official secrets and confidential issues, and which is divided again into three chapters: official secrets, rules and procedures, and confidentially classification. So, part 2 focuses on the step required for effective implementation and of the act is divided into four chapters again: rights and obligations, issues in implementation, application of act to the legislation, resolution, and removal of difficulties. So, guys, this is introduction. Let's go with the part 1, chapter 2, which is official secrets act and some other laws. Okay, so let's get started. From now onwards, just listen carefully and try to make some notes. As I said, join the Telegram group for the summary notes, and don't worry to share this video, share this live link, and like the video. And if you have any doubts, let me know in the live chat. So let's get started with the chapter 2, part 1: official secrets and act and other laws. The most continuous issue in the implementation of the Act to Information Act, which is related to some official secrets. And in this democracy, people are sovereign, and the elected government and its functionaries are public servants. Therefore, by the very nature of things, transparency should be norm in all matters of governance. Because, however, it is well recognized, organized, and that public interest is best served if certain sensitive matters affecting the national security, which are kept out of the public gaze. Similarly, the collective responsibility of the cabinet demands an uninhibited debate on public issues in a council of ministers, free from the pulse and the pressures to day-to-day politics. People should have unhindered right to know the decisions of the cabinet and the reasons for those. But you know what? Actually transpires within the confines of the cabinet room. The Act recognizes the risk confidential requirements in matters of states, and Section 8 of Act extends to all such matters which are important and which does not need any government support. Okay, the Official Secrets Act 1923, year and after, referred as overseas enacted during the colonial era. Governance of all matters of secrecy, confidential in governance, the law largely deals with matters of security and provides a framework for dealing with like espionage, sedition, and other assaults on the unity and integration for the nation. However, given the colonial climate of a mistrust of people and the primacy of public officials in dealing with the citizens, OSA created a culture of secrecy. Confidentially became the norm and the disclosure the exception. While Section 5 of OSA was obviously intended to deal with potential breaches of national security, the wording of the law and the colonial times which is implemented made it into a catch-all legal provision, converting practically every issue of governance into confidential matter. And this tendency was boosted by the Civil Service Conduct Rules 1964, which prohibit communication of an official document to anyone without authorization. Not surprisingly, Section 123 of the Indian Evidence Act, enacted in 1872, which prohibits the giving of evidence, which was unpublished official records without the permission of the head of the department, who has abundant discretion in the matter. Needless to say, even the instructions issued for classification of documents for security purposes and the official processes display this tendency of holding back information. The Right to Information Act as a non-obstance clause, which is Section 8 to Section 8, notwithstanding anything in the Official Secrets Act 1923, nor any exceptions it is permissible in accordance with subsection. A public authority may allow access to information if the public interest in disclosure outweighs the harm of the protected interest. And these provisions of the Act which allow disclosure of the information even where there is a clash with the exemption provisions of Sector 8 enjoy a general immunity from other acts and instruments by virtue of Section 22 of Act. The provisions of this Act shall have effect notwithstanding anything inconsistent therewith contained in the Official Secrets Act 1923 and any other law for the time being in force or any instrument having effect by virtue of any law other than its Act. This OSA would not come in the way of disclosure of the information if it is otherwise permissible under the RTI Act. But OSA, along with the other rules and instructions, may impinge on the regime of freedom of information as they historically nurtured a culture, secrecy, and non-disclosure, which is again the spirit of Right to Information Act. And in Section 5 of OSA, Official Secrets Act, it started earlier in catch of all provision. As per this section, any person having information about a prohibited place, such information which may help an enemy state or which has been entrusted to him in confidence or which he has obtained owing to his official position commits an offense if she communicates to an unauthorized person, uses it in a manner prejudicial to the interest of the state, retains it when she has no right to do so, or fails to make some reasonable care of such information and any kind of information which is covered by this section. It is clarified that secret or the face of official secrets is not being defined in the Act, which is therefore public servants enjoy the discretion of to classify anything as secrets. Right? The Supreme Court in Samalan Abdullah state of Gujarat in 1966, which has held the word secret in clause of sub-election of section 3, which is qualified official code or password and not a sketch, plan, model, article, note, or other document or information. And when they were found accused, it was found in conscious possession of the material, which is a possible explanation, which we can give an explanation which has been given for its position, and this has been presumed as required by section 3 of the act that the same was obtained or collected by the appearance for the purpose and judicial prejudicial to the safety of or interest of the state. Therefore, this was a sketch plan model article need not necessary to be secret in order to cover by the act provided it is classified as an official secret. So similarly, even information which does not have a bearing on national security cannot be disclosed if the public servant obtained or has access to it by virtue of holding office. Such illegal by draconian provisions clearly bred a culture of secrecy through a RTA Act now overrides this provision in relation to matters not exempted by the Act itself from disclosure. The fact remains of Official Secrets Act is the current form in the statute books, which is an anachronism. And this law, it is 43rd report, summarized the difficulties encountered with the all-inclusive nature of Section 5 of Official Secrets Act, which is in the absence of a clear and concise definition of official secret in the following words. Right? So, till now I've completed Official Secrets Act. So the notes will be just scrolling. You can just refer. After some time, I'll be back and I'll be continuing in the Official Secrets the words. Right? Okay. So read the notes. So guys, I hope you all referred the notes. So let's continue with the report, that is the Official Secrets Act. 1 minute. Yes. So the wide language of Section 5 may lead to some controversy. It penalizes not only the communication of information useful to the enemy or any information which is vital to the national security, but also includes the act of communicating in unauthorized manner, right? In unauthorized manner, any secret information which is government servant or which has obtained by virtue of its office. Thus, everything but some security at life, which will offer an officer to the security that has access to intent to keep secret. So very crazy law actually. The law commission was also recommended consolidation of all laws dealing with the national security and suggested a national security bill, which is the observations which is made by the law commission report or reproduced, right? So to various entanglements enforced in dealing with offences against the national security, which are wait the various enactments enforced in dealing with the offences against the law. They are Indian Penal Code, the Foreign Recruiting Act 1874, the Official Secrets Act 1923, and 1 minute, let's think. Criminal Law Amendment Act 1938, Criminal Law Amendment Act 1961, and there will be one more. Unlawful Activities Prevention Act 1967. So these were somewhat these were some offences against the national security. And the Foreign Recruiting Act of 1874 deals mainly with recruitment of India for service in a foreign state. And you know what? As I said, the Indian Penal Code, which is have been fully considered in our report as on the code, right? And we have a Criminal Amendment Act 1938, which is a brief summary of other statutes on these subjects. Also, will be more useful for UPSC preparation, right? And Official Secrets Act 1923, which is the main thing for fighting activities which vitally affect the national security. Spying or entry into a prohibited place is called a prohibited place or collection of secret information will prohibited in this act according to this act, Official Secrets Act of 1923. And wrongful communication or receiving secret information of the specified type have been spies, unauthorized use of uniforms, of reports, reading of reports, in order to enter a prohibited place for a purpose prejudicial to the safety of the state, interference of the police, military, and somewhat near a prohibited place, right? And next is Criminal Law Under 1961 is to punish persons to question the territorial integrity or frontiers of India in a manner prejudicial to the safety and security of the country, right? Undoubtedly, is necessary for some of the things previously, but not now. Uh, actually, actually, this was a commission which have which was a direct bearing on national security and integrity in the view of passing of the Unlawful Activities the Prevention Act 1967. Some of the provisions of the earlier act may not be necessary, and this is the question will be considered some appropriate places, right? And the Unlawful Activities Prevention Act 1967 was passed for effective prevention of the dispute activities which they were in support of secretion of the part of the territory of India or in support of the cession of a part of the territory of India from the Union or otherwise disclaim, question, or disrupt the sovereignty and territorial integrity of India, and which is deals and it deals with just such activities of individuals and also of associations. And this what provisions as to unlawful associates are detailed and elaborate. That is, Act constitutes a vital link in the chain of enactments of importance to national security. This cannot be doubted. Activities intended to detach a party of the territory of the country as somewhat described in foreign penal codes. Right? So now let's go to the third chapter, Central Civil Services Conduct Rules. So before going to this chapter, you may think I'll be giving a notes reading break. Yes, this is a notes reading break only. The notes will be going from the starting to end. Uh, Now live after it's been 36 minutes live, 36 minutes, 37 minutes. So 4 minutes, the notes will be on the screen from the introduction to the Official Secrets Act. So you can refer it, and in the meantime, you can join the Telegram group. I'll be uploading complete document in the group only. Okay, so the notes will be coming from starting. Just refer it, and so let's read. I hope everyone is reading. So guys, let's continue with the Central Services Conduct Rules. So the Central Civil Services Conduct Rules forbid unauthorized communication of information, and some similar provisions exist for the state government employees under the respective rules. So the rules of unauthorized communication of information, and the government servant shall uh, communicate with each other and not share any secrets as as per the official secrets act, right? So, and it's very important for some programs and the awareness programs in each district, and in every decentralized in decentralized manner the programs of awareness are conducted, and this at least will be in half an hour or an hour. So you know what? And this must communicate and indirectly communicate directly or indirectly in any official document or any part thereof. Therefore, communication information or to the government servant or any person or any person. Like there will be some unauthorized people, not only the government servants, the other people who to see whom to see is not authorized to communicate such document or the information or the report, and thus quotation by a government servant, and in this representations to the head of office or office of development department or president of or from any letter circular office memorandum or notes anything which is not authorized to have access or which is not authorized to keep in his personal custody for his personal purpose shall amount of unauthorized communication of information while within the meaning is this rule. Okay, next, the Shura Committee examined the issue and stated which as there is a widespread feeling that the Central Civil Services rules 1964 and corresponding rules applicable to railways, foreign services, and all Indian external and internal services inhibit government servants from sharing information with the public, and the accent in these rules is no denial of information to public, and this situation is obviously to change if freedom of information act is to serve its purpose, and if transparency is to be bought about the system, right? And this commission and this this commission was formulated when the RTI Act did not exist, and the spirit of rules were not to hold back information with an emergence of an era of freedom of information, and these rules would have to recast so that dissemination and some reports of information is the rule of holding back information is an exception case, right? And with the emergence of an era of freedom, this rules information and these rules have to recast it, and the Department of Personnel and Training has amended the civil services rules on the lines of in October 2005. However, all states need to amend rules in similar manner in keeping with the letter spirit of RTI Act. Okay, and here they gave some recommendations again. And guys, one more thing. As I've said, recommendations will be said in last month, but that too I'll say recommendations now only. And recommendations are very important. Just listen what I'm saying. I'll be saying recommendations of official secrets 1 minute. So first, let me go recommendations. Actually, recommendations are not that easy to remember and not easy to write. That is why what I say is just check the notes and make notes. It will be better. Like the recommendations are: the Official Secrets Act 1923 should be repealed and substituted by the chapter somewhat in the National Security Act, which is containing provisions and related to official secrets. This was the main recommendation given by the government, right? And there is one more recommendation in civil services, the central civil services rules. The civil services rules of all states may be rewarded somewhat in the communication of official information, which is every government servant shall in performance of his duties in good faith communicate to a member of public or any organization full and accurate information which can be disclosed under the Right to Information Act 2005, right? And next, nothing in this rule shall be constituted a permitted communication in a particular unauthorized manner, permitting communication of classified information only, or for some improper services and improper profit, improper gains for the government. Okay, and the manual of office procedure. So now let's discuss about the manual of office procedure. I hope you all understood. I hope you all understood what is official secrets law and how important the laws are, the reports are, and this is what this report is telling us regarding everything, how the government takes measures to control the secrets reports. And there is some act of calls official secrets act, and one more, that is central civil services rules. And as I said, this is important, guys. Just don't leave anything. Don't worry, just if you stay in the life and till the end, you will understand what I'm saying. So the manual of office procedures, the relevant portions which will be given as I said in RTI Act, right, Right Information Act, and this what is were reproduced as an unauthorized communication of official information, unless and authorized by general or specific orders. No official will communicate to another official or a non-official. I hope you understood. No normal official will be communicating to the other officials as per what? As per the Central Civil Service Conduct rules. Unless authorized by general specific orders, no government official will be communicating with the other non-official regarding anything, regarding their information of government, regarding documents, reports, anything. And which will be against the duties, official government duties, right? And this is a manual office procedure, and I just make a point. Manual office procedure is just nothing unless the order given by the government and official law to communicate to other non-official of the state about regarding any information, document, report, anything. Okay, and there is one more recommendation out here, that is communication of official information. Every government servant should communicate to a member of public or any organization which will be disclosed against the right to that. But nothing as stated above shall be considered permitting communication of classified information in an unauthorized manner for improper gains for the government servants and others. The state government may be advised to carry out similar amendments in their manuals if such provisions exist therein. So there's nothing, guys. This is about like communication of official information. Every government servant shall, in performance of his duties in good faith, communicate to a member of public, like communicate of an official information. Every government, as I said, according to the manual office procedure, which is something like just in good faith, which is communicated to another member of public or any organization full and accurate information which can be disclosed to some other government, to some other person, and nothing stated above shall be constructed or this important regarding them. Okay, so I hope you are understood. Next is confidentially classification, and this again important. It's the fourth chapter. It's again important chapter because apart from the somewhat indiscriminate application of official Secrets Act of information, which was not intended to be secret, right? Not to be secret, but contributed to culture of clearly a secrecy in the government as unwanted, unwarranted, and this was unauthorized disclosure of would could damage, which could damage, which could damage to the national security or cause embarrassment to the government in its functioning, or would be prejudicial to the interest, national, national interest. These instructions, which are contained in the Manual of Departmental Security, security in classification to a record based on the degree of confidentiality required, they also describe the manner in which each of such classified, I'm saying again, each of which it is classified, which also describes the manner, information in which is to be handled, or and the persons who can access such information. Alright, now let's go to the next then. So the task of classifying a document is vital in the larger national interest and should be handled with a great caution, as a security classification denies access denies access for information to public. Therefore, only officers of therefore official officers information once classified into public domain after lapse of specified period, usually 30 years, which is therefore necessary to review such classified documents after a reasonable period. It is therefore necessary to review such classified documents after a reasonable period of say 30 years. The period can't even be less in case of some documents, those which do not merit classification, right? And further, the hierarchy of security classification should be rationalized, reflecting the scheme of exemptions under the Act and emerging challenges. And this Act has listed 11 categories, which is Section 8 and Section 9, which I have said in the Official Secrets Act, wherein information may be not given out. These range from information disclosure of which, right, of which it is open, and this range from information disclosure of which would be prejudicially affect the sovereignty and the integrity of India and the security, strategic, scientific, or economic interest of the state. Relation. External Affairs Minister with the called foreign state are lead to the encouragement of an offense. Infringement of copyright subsisting in a person, the Commission feels that the classification system should broadly cover each of these categories of information, which is quite possible that information falls under two or more categories of exemptions. In that case, the government should be given the classification of the order, higher order acceptation exemptions, right? So I hope you understood. Okay, now let's see the part two. That's implementation of the right to the Information Act, which is again an important topic. That's the fifth topic. So in order to enforce the rights and some fulfill the obligations under the Act, the building of institutions, organizations of information, and the creation of an enabling environment are critical. Therefore, the Commission has first step reviewed the steps taken so far to implement the Act as follows. Right? So, from first to chapter fourth, I'll be back. I'll back in 2 minutes and just refer with the notes. And again, I am saying notes is in the link, this Telegram link in the description. You can just check it out and join. Okay? So, read the notes and I'll be back. So, guys, we'll continue. So, one minute. Okay. So, building institutions, which is an information commissions, information record keeping, and capacity building. It's very important. Creation of monitoring mechanisms. Again, the more important topics are coming. So, the building institutions. First is information commissions. Government of India constituted the Central Information Commission, with the key information commissioner and four information of the CAC are being posted on the website, that's http.cic.gov.in. Just check. Okay. So far 21 states have constituted the state information commission. That's in the section 1, which I have said in this is official secrets and somewhat in Central Information Commission. And so, as I said in previously, I've said regarding the SIC, that is Central Information Commission. So, as it's important for the right to information. That is why let's see some things regarding SIC RTS. Okay. First, we see Parliament's Section 4, Introduction, Foreign Tour, Foreign Relations, everything will be in the Central Information, right? Central Information Commission, which is again a very important and very informative thing for all IAS preparation. Okay, so let's continue with the topic. So far, there are 21 states constituted the State Information Commission and SCs under the provisions of section 15 and came into the force at once, thereby meaning that all the state governments were required to constitute their respective commissions. Their respective commissions immediately on enactment of the RTI required to constitute their respective commissions immediately on enactment of the RTI Act, which has been accomplished by the most of the state governments as brought out by the table as an action for. The commission also obtained information about the background of the state chief information commissioners, which is as certain as whatever all sections of society were being represented, right? So this act provides a section of CIC, SIC in the bipartisan manner, and which involves the leader of the opposition in the process. Since this act is applicable to all organs of the state, it would be appropriate to include the selection committee in the Chief Justice of the Supreme Court, High Court, and this will inspire public confidence and enhance the quality of selection. Despite a legal obligation, despite a legal obligation to constitute information commission, six states have failed to do so even 10 months after its enactment. The states which have not constituted information commission so far are Bihar, Jharkhand, Manipur, Sikkim, Arunachal Pradesh, Mizoram, and this needs to be rectified immediately, right? Okay, this need to be rectified immediately. So this act allows a dispersal of information commissions which to provide easy access to citizens, easy access to citizens for all, and however, neither the CSC nor the SICs have established offices at the places other than their main other than the capitals. For an overly citizen-friendly law to be effectively implemented, it is vital to have easy access in vast country like India, right? Vast country like India, and for an overly citizen-friendly law to be effectively implemented. As I said, the commission is therefore of the view that the SCIC should be dispersed in at least four regions. Similarly, the SIC in the larger states would be dispersed, and it would be in a more at least the four regions. Similarly, as I said, depending on population density, geographical area. And this act visualizes the commission wherein the members present in different aspects. Okay, so now let's go to the issues in implementation, which is again an important topic in this. Okay, so the issues in implementation, the implementation of RK Act is an administrative challenge because which has thrown up various structural, procedural, logistical some issues and also numerous problems which need to be addressed in early stages only, but they didn't, right? That has to be addressed in early stages only. The commission has identified some of the problem areas in implementation, and these are discussed and recommendations made for the redressal of some of the following things. Now, the facilitating access. For seeking information, a process as prescribed under the Act has to be set in motion. The trigger is filling of a request. Once the request is filled, the onus of responding to it shifts to the government agency. The steps involving in processing request for information are given in the chart figure 1. So let's discuss the chart closer to the process of involved in the giving input under the data act. First is simply application filled in the PIO or filled in APIO. Again, transfer from check if availability within or check if available with others. And this which informs the applicant non-availability or availability, check whether the applications are applied, third party information, everything just delivered to applicant at last. Inform applicant, no action will be done, right? So, for seeking information, a process is there which is given by the government when this act or this law was introduced only, right? And once the request is filled, will the responding to shifts to the other government agencies, and which is based on some case studies conducted by the commission responses of various ministries to a questionnaire and interactions with the stakeholders. A number of difficulties, implementations were noted. Complicated system of accepting request and some demanding drafts, which would be difficulties in filling the applications by post, and there are and there's varying on often higher rates of application fee, larger number of PIOs. You know what's complicated system of accepting requests while accepting the applications, departments insist that cash to be paid in the accounts office in ministers, the accounts office and the PIO's office are different and at times in different locations. The rules are also prescribed that for each extra page of information rupees 2 has to be rupees 2 has to be paid. Right? So same process, the difficulty would get further pronounced in field offices, many of the which to collect cash, and moreover getting a business pass to enter a government building results in unwanted wait times. Right? So there are some difficulties in filling the applications by post under the existing dispensation somewhat demanding somewhat things like difficulties in filling applications by post, and there are some other existing dispensation filling applications will be not involved in payment of the application fee by the way of the demand draft or the banker's check. So I hope you all hope you all getting it because I'm just going on, just all going on. It's hard actually. Not that easy as I said previously. It's not is that easy to see. So just remember, guys. Uh, Take a small break. Don't need to read this also. Don't need to watch. Just go back and again come back again because we'll be content. There are too many topics already. Say okay. So take a small break. Take a small break. Don't So guys, let's continue again. Uh, let's go with another topics and let's complete this in the slide only. Next, the inventory of public authorities. So the Act defines a public authorities to include a vast array of institutions and agencies for people to access information, cataloged and indexed list of all public authorities is necessary. In a vast and diverse country with a federal structure listing out all the public authorities is an Herculean task. Therefore, an inverted tree concept could be followed to have an inventory of all public authorities, starting from ministries of GOI. So each ministry should have details of all public authorities immediately under its control. Similarly, each could leave a public authority should have exhaustive list of all agencies offices under its immediate control, and this should be followed to the lowest public authority in its hierarchy, right? So now let's go to the next chapter, that is application of the act to the legislature and the judiciary. Okay, so most of the observations and recommendations of the commission is most of the recommendations commissions as some legislature by notification or order of the appropriate government, which is not that easy of the all or to all public control and applicable to all public institutions including the legislature and judiciary, which is clearly evident. It's clearly evident, right? And you know what? In this executive branch, traditionally secrecy has been the norm throughout the world. So also in India, the legislators and the judiciary in India already operate within the public eye of the game. Greater extent than the executive, the process, the proceedings of the legislature are open to public meetings and which have been already completed in the legislative committees. However, it's a generally appropriate condition, right? So this is my short chapter that just removal of difficulties. Power to remove difficulties. Section 30 of the Act stipulates as follows: if any difficulty arises in the given effect of the provisions of this Act, the central government may, by order published in the official gazette, make such provisions not inconsistent with the provisions of this Act as appear to be necessary or expedient for removal of the difficulty, provided that no such order shall be made after the expiry of the period. Right? The implementation of the Act is yet to stabilize and it perhaps too early to identify difficulties that may be encountered. And the Commission, however, has identified some initial difficulties which could go smooth implementation of the Act. These have been highlighted in the preceding chapters of this report, which of these would require taking recourse to Section 30 of the Act. Right? So the implementation of this act is yet to stabilize and it's perhaps too early to identify difficulties and maybe uncounted. Okay, and the commission, however, has identified some initial difficulties, which is also very important. And you know what? According to the section 30, some of these could require taking recourse. Okay, so all organizations listed in the second schedule have to appoint a PIS against orders of PIS should lie with the CIC and SIC. PIC and SIC. So the National Coordination Committee may be set up under the chairmanship of the Chief Information Commissioner with the Nodal Union Ministry. The SICs and the representatives of the states will be as a member. Right, and now let's okay, very short chapters, they are completed. everything is completed. So this is only the right of podcast knowledge. This is now it's time for the last thing, which is conclusion. Recommend conclusion and notes discussion. That's it. The live will be completed. Okay, so let's get started with the conclusion and let's go with the notes. Okay, so the right to information law of 2005 signals a radical shift in our governance culture and permanently impacts all agencies of state, right? And you know what, this would effective application depends largely on institutions which have been created in the past days, in the latest days when this act was introduced, right? And this law was introduced. And the first set of issues relates to changes in other laws, some other laws, and this would make an clear vision to the public servants and the government servants. It will be reorganized, and it will be more easy, it would be more better to 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 create that and claim some laws or rules. Nevertheless, this law provides us a priceless opportunity, which is given in which is given organized that it right to be is necessary. But what to do? But it's just feel that commission made specific recommendations and attempted to provide a roadmap for their time bond implementation, right? So I hope everyone understood what is this right to information ARC reports. First of all, you may think that about ARC reports it is very hard, but what I say is very easy. Only just not that hard. But remember, don't forget to make the notes and just refer. So now I'll be discussing the notes. So that is why now there's again a small break, and after that, I'll be discuss the complete notes once again, and then end the live. Okay, so guys, so the notes will be on the screen, guys. I'll be discussing after some time, not now, but till then, take a small break, and I'll be back with this discussing with the notes. Okay, so guys, let's discuss the notes of ARC report one. So fast. So let's go with the issues of implementation notes. The commission which has identified some of the problem in areas and implementation, and these are discussed and made some changes made for the redressal, right? And this is very important for facilitating access who based on the case studies conducted by the commission, responses of various ministers to a questionnaire and interaction with the stakeholders, a number of difficulties, impediments were noted, right? Impediments were noted. This would take a long way to that and varying and often high rates of application fee. The Act defines public authorities to include vast area of institutions and agencies for people to access information catalog to index to list of all public authorities is necessary in a vast and diverse country and a federal structure. This is what I'm going to say because it's a very important point. Every the complete report is based on the point which I've said now. So guys, thank you everyone who joined the live and who was with me this 1 hour, and I hope you all know now get clarity what is this uh, ARC reports and the first ARC reports. So again I'm saying join the Telegram group, link in the description. I'll be forwarding this, and thank you guys. And one more thing, we have launched a new website called WebEasy. WebEasy website made simple. So in which you can order websites and not you can learn how to make websites, and that link is now kept in live chat. Just you can check out there. Okay guys, so that's it from my side. If you have any doubts regarding the ARC reports, you can let me know in the comments. I will be explaining you that in the next ARC reports live. So till then, bye guys. Thanks for watching.